Mr. President.
Senator from Delaware is recognized.
Mr. President, I ask unanimous consent that proceedings under the quorum call be vitiated.
Without objection, so ordered.
Mr. President, I come to the floor today to speak on the tragedy, on the ongoing crisis of sexual assault in our armed forces, and what I believe we must do. There are several options before us, each of which have been the subject to lengthy and passionate debate, a debate that I think is healthy and needed and welcome here in this chamber. And I commend my many colleagues, Chairman Levin and Senator Inhofe, Senator McCaskill and Senator Ayotte, for the very real progress, the very significant steps taken both in the base bill, the NDAA, and in the amendment to be offered by Senators McCaskill and Ayotte. Serious and important steps forward to protect victims, to ensure that commanders are held accountable, and to criminalize retaliation. A wide range of important and significant reforms that will make real progress towards addressing the ongoing, decades-old scourge of sexual assault in the United States military. As was said recently on the floor by another of my colleagues, this disagreement today is over one of more than a dozen important and needed reforms. But in the end, we have to decide. And I believe the measure offered by Senator Gillibrand of New York, of which I am a co-sponsor, is the right additional path forward. Because at the end, here's the bottom line. Sexual assault has been a disease, a corrosive and widespread and horribly negative influence on our military that has simply not been effectively treated. And I think this significant, this dramatic step is the needed driver for extensive reform. I understand that the chain of command is essential, that it is central to the proper functioning and order of the military, especially during wartime. In fact, the chain of command is nearly sacred. But ensuring that our spouses and our siblings and our children can serve with honor and not have to face another enemy within our ranks is sacred. This is, in the end, a debate about justice. Justice within our own armed forces. Justice so that we can fulfill that sacred duty of protecting men and women in uniform as well as they protect us. And despite many years of good faith efforts by leaders in our armed forces to work within the parameters of our current system, literally tens of thousands of sexual assaults are still occurring annually within our armed forces. That is frankly unacceptable and reflects a fundamental breakdown in order and discipline that, in my view, we cannot tolerate anymore. The current system in this important and vital way is failing. I understand the intense desire our leaders feel to fix what was broken and for our military leaders to atone for taking their eyes off the ball, to paraphrase the testimony of the chairman of the Joint Chiefs. But once again, this debate is not about them, about their commitment, or about their strategy, or about their determination. It is about justice. And in America, justice must be blind. Whether someone receives it or not shouldn't depend on the fact of whether he or she serves in the military rather than in other workplaces. And we know the chilling facts that according to the Department of Defense's own Sexual Assault Prevention and Response Office, 50% of female victims state they did not report the crime in the first place because they believed nothing would be done, and a quarter, or 25%, who received unwanted sexual contact indicated the offender was in their chain of command. In my view, we strengthen our military when victims of sexual assault have the confidence to come forward and to report crimes, and when we remove fear and stigma from the process. And we strengthen our military when we're able to deliver fair and impartial justice on behalf of victims. When we know the military chain of command in this one area is failing, we should not continue to tolerate an exception we wouldn't make in other settings. Mr. President, I came to this decision with great reluctance, recognizing, as many in my family have, that the importance of the chain of command, the importance of respecting the unique and different traditions and structure of the military is something that we should only come to with great hesitation. One of the responsibilities of serving in the Senate that I take seriously is my annual responsibility to review and approve candidates for the military academies who are selected by my independent Military Academy Advisory Board, and personally calling the top candidates to inform them that they will be the ones, of the dozens and dozens of highly qualified competitors, they will be the ones selected to go to the Merchant Marine Academy, the Air Force Academy, to Annapolis, the United States Naval Academy, or to the United States Military Academy, to West Point. This is a moving experience each of the 3 years I've had the chance to do that. But this past year, the 3 top candidates for West Point, for Annapolis, for the Air Force Academy were all women. Impressive, compelling, determined to serve our nation. And meeting with them and their families, the nervous and proud parents and these confident cadet candidates, is also a great annual experience. And it reminds me always of my responsibility to them. I promise their parents that we will support and respect them and their service. And when we speak to the cadets and thank them for their willingness to serve, I'm reminded we have a responsibility to not send them into an institution where they'll face threats that we can and should address. I believe I have a responsibility to send them into an institution I know is well equipped to respond strongly and swiftly to threats to their safety. Yet today I'm not able to uphold that responsibility because we have not protected our men and women in uniform from sexual assault. I thought of my picks for the Service Academy when I heard another senator say to General Dempsey that that senator would not advise a parent to encourage his or her daughter to join the military. What made this decision, this difficult decision for me to join Senator Gillibrand on this particular amendment was a tragic case. Last spring, while I was trying to decide which path to follow on this bill, my office received a gut-wrenching call from the father of a young woman serving honorably in our military. He was calling against his daughter's wishes and only as a desperate last resort. She had been the victim of sexual assault and, like so many others, reported it to her commanding officer up the chain of command. But like too many others, the case went nowhere. Her by-the-book reporting and patient waiting for results was met by delays, excuses, non-response, and ultimately during these repeated delays, she was physically assaulted after she had warned leadership she feared for her safety. We took action, and ultimately in this instance, justice was done. But a chain of command like that isn't strengthening unit cohesion and morale. It's harming it. And so after this particularly troubling case, I made a decision to join Senator Gillibrand as a co-sponsor, to say, Mr. President, to all of us, how can we accept this? How can this situation that's gone on for years be tolerable? How can we justify the status quo? I am grateful for the leadership of the many senators on the Armed Services Committee and throughout this body who have taken real steps to add significant improvements to the UCMJ and to the code that underlies our military and the requirements for leadership and service to take on and tackle these very real problems of sexual assault in the military. In my view, taking decisions out of the chain of command should only be done under the most serious of circumstances, but that is exactly what we have here. We wouldn't find justice if this was the way that any other workplace in America operated. How can we argue that we have justice today for these thousands of victims in our military? The men and women who dedicate themselves to keeping us safe and protecting our rights deserve equal dedication on our part to their safety and to those same rights. Mr. President, if I might, I'd like to also speak about 3 bills that I am offering as amendments to the NDAA that all relate to a topic I've spoken to many times here on the floor, to manufacturing and manufacturing jobs. The first is the American Manufacturing Competitiveness Act, a bill I introduced last week with Illinois Senator Mark Kirk and enjoys the support of the presiding officer as well as Senators Blunt and Senator Stabenow. It has a simple but important objective to require the creation of a national manufacturing strategy. We need to know our country's direction as we try to support the growth of manufacturing. We've grown more than 500,000 manufacturing jobs in the last 3 years, an encouraging sign, but one we need to strengthen and support with a coordinated strategy between the federal government, state governments, and private sector to align our investments in research and development, in new skills, in new infrastructure, to make sure they're all heading in the right direction. Our leading competitors all have successful and well-deployed national manufacturing strategies. Whether Germany, China, India, South Africa, Russia, they've all got thoroughly developed, deeply researched, and prominently successful strategies, which we lack. Our amendment would require that every 4 years the Secretary of Commerce advised by a board of 15 different folks, pull together and think through research and then deliver a national manufacturing strategy. This amendment is bipartisan, simple, does not cost the federal government a dime, and doesn't create a new program. Like the next two amendments I will speak about, it is a common-sense measure I hope we adopt. Second, I'd like to speak briefly on an amendment I'm co-sponsoring with Senator Blunt to ensure small businesses are not subject to conflicting guidance from federal agencies. In the 70s, Congress passed a measure for the Small Business Administration to ensure that small businesses that get contracts from the government aren't actually fronts for much larger companies. And last year, we passed similar but distinctly different rules for the Department of Defense. Most of the time, these two sets of rules can peaceably coexist, but in a few cases, they come into conflict, creating compliance difficulties for real small businesses. This amendment would say that when both sets of rules apply, the SBA rules apply while the DoD rules do not. This amendment is bipartisan, has no cost, and will help small business focus on effectively delivering products and services without worrying about compliance. Last, I'd like to speak on an amendment I'm co-sponsoring with Senator Cory Booker of New Jersey to ensure that our defense and intelligence communities maintain their vital technological edge. This is an important measure that would create more opportunities to train America's best talent and pave the way to new innovations. Recently, the Commission on R&D in the U.S. Intelligence Committee reviewed our current and future R&D capacity to support our intelligence community's vital work. Their unclassified report shows that, in fact, we have insufficient funding and a critical deficiency of human capital, of skilled workers and the cutting-edge thinkers we need in this area. Specifically, for one example, it said we may not have the kind and number of people we really need to build the next generation of satellites, to gather and process the intelligence upon which our national security relies. Now, there's currently a program run by the Department of Defense designed to address one element of this problem. It's called the Science, Mathematics, and Research for Transformation Scholarship Program, or the SMART Scholarship Program. This amendment calls on the Secretary of Defense to report back to Congress on two things: whether the SMART Scholarship Program or similar fellowship and scholarship programs are in fact providing the necessary number of undergraduate and graduate students in the fields of science, technology, engineering, and math to meet the recommendations of the Commission's report, and recommend how those programs can be concretely improved. This amendment has already passed the House of Representatives by a voice vote and would be an important, if small, step toward paving the way for job creation and ensuring our national security now and into the future. I urge my colleagues to support these amendments, and I am grateful for the opportunity to contribute to the debate on these important issues. With that, Mr. President, I yield the floor.
Senior Senator from South Carolina is recognized.
Thank you. I would like to speak in support of the McCaskill, Ayotte, Fisher, Levin et al. Amendment. Could you let me know when 15 minutes has expired? Thanks. Mr. President, before we get started, I really want to thank Senator Levin, Reed, McCaskill, Ayotte, Fisher, and others who have been trying to carry the burden here to make sure that we reform the military justice system and the way the military operates vis-a-vis sexual assaults and misconduct, but at the same time make sure that we still have a military that can continue to be the most effective fighting force on the planet at a time when we absolutely need it. If you believe, as I do, our military is the best in the world, you have to ask yourself why. Is it because of the equipment? We have great equipment. I would argue that the reason our military has become the most effective fighting force in the world is the way we're structured. If you're looking for a democracy, don't look to the military. The military is a hierarchical and paternalistic organization that's focused on meeting the challenges of the nation, being able to project force at a moment's notice to deter war, and if war ever comes, to decisively end it on our terms. I've been a military lawyer for over 30 years. I've been assigned as a military defense counsel for 2.5 years, a senior military prosecutor in the Air Force for 4.5 years. I've been a military judge. I've served in the Guard, the Reserve, and on active duty for 6.5 years. I have learned a lot as a military lawyer about the military. To my colleagues who are deciding what to do and what's appropriate, the goal should be to make sure that America remains the most effective fighting force on the planet. And here's a proposition. You can't be an effective fighting force if you have rampant sexual assault or misconduct within the ranks. And this idea that sexual assaults in the military are unacceptable, too large in number and scope, sign me up for that proposition. But the problems of society don't stop at the gate. They continue inside the fence. I would dare say that if we did surveys in South Carolina, Missouri, New Hampshire, New York, about sexual assaults and their frequency, we would all be disturbed. And the goal of our time here is to make sure that when it comes to our military, that we turn a corner and that we create a legal system where people feel that if they file a complaint, they're going to be fairly treated. And also a legal system, if you're accused of something, you're going to be fairly treated. To my colleagues, there is a reason that every Judge Advocate General of all the services have urged us not to adopt Senator Gillibrand's solution to this problem. In the military, it is impossible, in my view, to correct a problem without commander buy-in and holding commanders responsible. Military commanders have awesome responsibility and almost absolute liability for the job that we give them. It is their job to make sure that all under their command are ready to go into combat, perform their assignment in the most difficult task, to make sure that your medical records are up to date, to make sure that you're squared away when the nation needs you. This concept of the authority of the commander goes back to the very beginning of this nation. Military justice is an essential part of good order and discipline. After 30 years of experience in this area, the number of cases where a judge advocate recommends to a commander that you proceed to trial in a sexual assault, or for that matter, most any other alleged crime, is a rounding error. So please don't suggest that our current system, that you can't get a case into trial because our commanders routinely blow off legal advice. That is not the case. Commanders decide as to whether or not to proceed to a court-martial and what level of court-martial based on advice of the judge-advocate community, whose job it is to provide professional advice. The commander's job is to make sure that unit is ready to go to war. The lawyer's job is not to pick and choose who goes into the battle. The lawyer's job is to give that commander the best legal advice possible, including who to court-martial and who not. But one thing that I hope you understand in this debate, that no lawyer, no judge advocate is ever going to have to deal with the situation of picking and choosing in that unit who takes the most risk. We have, for 200 years now, allowed commanders the authority under the Uniform Code of Military Justice since 1952 and before, the ability to maintain good order and discipline, the absolute responsibility to make sure the force is effective when it comes to the fight, and giving them the tools to make sure that happens. What would bother me greatly is this conversation occurred. Sir, ma'am, depending on who the commander is. There are more and more female commanders in the military. There was an alleged rape last night, a sexual assault in the barracks last night, and the commander would say, that's no longer my problem. Send that to Washington. Ladies and gentlemen of the Senate, that is the commander's problem. And to those commanders who have failed to make sure that we have the right climate in the military when it comes to sexual assault, your job is at stake. The military justice system, when it comes to rendering justice, I will put up against any system in your state. The reforms in this bill are going to become the gold standard, I hope, over time, and very few jurisdictions will be able to do what we've been able to do. Thanks to Senator McCaskill, Ayotte, Levin, and others, we've taken a problem in the military and I think brought a good solution. Every victim will now be assigned a judge advocate to help them through the legal process. I wish that were true in South Carolina, but it is not. Every commander who is advised to go to trial in sexual assault cases and who declines to accept the JAG, the judge advocate's recommendation, that case is automatically sent up to the Secretary of the service in question. So in the future, as commanders have to decide how to deal with sexual assault allegations, when the lawyer tells them, sir, ma'am, this is a good case, and if for some reason the commander decided, I disagree, that case goes up to the highest civilian member of that service, the Secretary of the Air Force in case of my service. That, to me, is a reform that will emphasize from the chain of command how important it is that we take these cases seriously. If we take the chain of command out, here's what we're saying in my view. To every commander in the military, you're fired. We, the United States Senate, have come to conclude that you, the commander, all commanders as a group, are either intellectually insufficient to do this job, or you just don't have the temperament, or you're morally bankrupt. We're going to take away from you this part of being a commander. You are fired. I will never, ever say that until I am convinced that there is no hope for our commanders, that our commanders are hopelessly lost when it comes to these type issues. I don't believe we're remotely there. In the 1970s, you had upheaval throughout the country, particularly in the military. We had race riots on aircraft carriers, and tension ran high. How did we fix it? We made sure that every commander was held responsible for the atmosphere in their unit when it came to race relations, and now I would dare say that the most equal opportunity employer in the whole country is the United States military, because commanders change the climate. Under Senator Gillibrand's approach, we take out a group of military offenses to the commander, you're fired, you can't do this anymore, and we send these decisions to an 06 judge advocate, which I happen to be one, by the way, in Washington. I cannot stress to my colleagues enough how ill-conceived this system is from a military justice point of view, and the damage you're going to do to the command and to the fighting force if you go down this road. And let me tell you why. You're in Afghanistan. There is a larceny, and you talked about employment. Senator Coons mentioned workplace. A barracks thief is one of the worst things you can do in the military. You don't pick and choose who you room with. We pick who you room with. You don't get to decide where you're going to stay. We pick for you. We throw you in the most incredible conditions. We don't give you the comforts of home, and you have to trust your fellow soldier in the barracks, and in deployment. And soldiers, like everybody else, most are great, some are bad. In the military, the bad apples, thank God, are a few. But under this construct we're coming up with, if you were in a deployed environment and there was a barracks theft case, a tent theft case, that really does hurt morale, because if you got to worry about somebody stealing your stuff, that's really tough given the conditions you're living under. The commander could not deal with this. It would go all the way to Washington, D.C. to be disposed of, rather than being disposed of on site. And why does it need to be disposed of on site? You need to render justice quickly, effectively, so the troops can see what you're doing. And if you're the commander, they have to respect you, and they have to understand your role. So I cannot understand why the United States Senate, when we've been at war for 11 or 12 years, would come up with a solution to a problem that's real, that does harm to the very concept of what makes our military special. The ability to go to war, the ability to be effective, and have the commander make decisions that only a commander should be making. I'm a military lawyer. I am telling you right now, don't give me this decision, because I'm not required to decide who goes to battle. Don't take away from our commanders in a theater of operation the ability to render justice in a way that the troops can see.
Mr. President, would the senator yield for a question?
Yes.
I want to make sure I understand something about non-judicial punishment. Since you're on the barracks thief in Afghanistan, and the notion that everything is going to stop and we're going to send this case off to a lawyer half a continent away to make a decision, let's assume that the lawyer, the colonel over in Washington, decides there's insufficient evidence for that barracks thief. Now, that might be 4 months later. Meanwhile, the barracks thief is still there, and let's assume then it comes back. It's my understanding, and I think there's some confusion about this by the people who are advocating this amendment, that you cannot exercise non-judicial punishment on a soldier if he chooses a court-martial proceeding. Is that correct?
That's exactly right. And non-judicial punishment is an authority the commander has to put people in confinement for up to 30 days, reduce in rank 1 or 2 levels depending on the rank of the commander, and to withhold pay. It is non-judicial punishment. You don't have a trial. The person is represented by a lawyer, but there is no jury. The commander is the jury.
So that commander...
The senator has spoken for 15 minutes.
Okay.
So that commander who has to now send the barracks thief case to Washington, that soldier is not going to agree to non-judicial punishment. He's going to say, I'll take my chances with the lawyers in Washington, and if the lawyers in Washington say no, then that commander's hands are completely tied to even put him in the barracks for 30 days. I mean, in the brig for 30 days.
Exactly right. Every military lawyer who's looked at this is very worried about what we're about to do in terms of practical military justice. Now, if you're 18 years of age, you have too much to drink, you write a bad check. Part of being a commander and a first sergeant is the paternalistic aspect of the job. How many of us have made mistakes at 18? Instead of going to college, you're going into a military unit. You bounce 4 or 5 checks. Has that ever happened? Under this system, the military commander no longer has the ability to deal with it in the unit. You send that case off to Washington. The ability to give a Article 15, a lesser punishment, is taken off the table. You're taking an 18-year-old mistake and potentially turning it into a felony. Now, does that help sexual assaults? Our commanders can send you to your death, but we don't trust them to deal with manslaughter cases. All I can tell you, for 30 years, I've been a practicing military lawyer, and from my point of view, our commanders take the responsibility to impose discipline incredibly seriously. They're skilled men and women, and we have let the soldiers, sailor, airman, Marine down when it comes to sexual assault. All of us are to blame in the military. We're going to fix that. But the problem, ladies and gentlemen, is not the military justice system. We don't have a military justice system where commanders tell the lawyer, go to hell, we're not going to deal with that. That's not the way it works. This new system takes a portion of offenses out of the purview of the commander and sends them to somebody in Washington that nobody in that unit will ever get to see, that will delay justice, will take tools off the table to make sure that is an effective fighting force in terms of dealing with the barracks thief, in terms of dealing with the bounce check, but also is taking young people who make mistakes and putting them in an arena where they're the only avenue is to be charged potentially with felony.
Would the senator from South Carolina yield for another question?
Yes.
So under this situation where you said that we have commanders that aren't going to ignore what is brought before them in an investigation from their JAG lawyer, particularly on a sexual assault, let's assume that they did do that, even though the evidence isn't there that they do it. Under our proposal, the proposal that I have, that Senator McCaskill has, and Senator Fisher, that decision, if the commander makes the decision not to bring the sexual assault case, it then goes up for review to the civilian secretary of whatever force is at issue, the Army, the Air Force, and the Navy. So what do you think that would do in terms of accountability?
If you want to improve the system, and we all do, I'm not questioning anybody's motives, if a commander knows that when they turn down the JAG's advice in one of the 4 situations we've identified, sexual assaults, the nature of the discussion here, that decision will be reviewed by the Secretary of the Service, I can assure you that will do more good to make sure commanders understand how important this situation is to us in the country than taking their authority away. You're doing absolutely the worst possible thing to solve the problem from Senator Gillibrand's approach, in my view, but every judge advocate agrees with what I'm saying. You throw the military justice system in chaos. You basically take the commander's authority away in an irrational way. What you do is you hold the commander more accountable by having what is the commander's worst nightmare, I guess, anybody in the military, having the boss look at your homework. How do you get promoted in the military? People over you judge your work product. And let me just say this. It is not a military justice problem here. The reforms that we're going to engage in are historic, will be the model for systems in the future, but very few people can afford what we're about to impose upon the military, because we're going to make this a priority and we're going to assign judge advocates to victims, and there's no other state in the nation that's going to be able to do that. We're going to have something you should be proud of. We're going to hold commanders more accountable. Here's the essence of the argument. You've got to take this out of the chain of command because there's something defective about the commander. Because the commander doesn't have the ability, or they have a bias against victims that you no longer can trust them to do the right thing. That, to me, is an indictment of every commander in the military that I think, quite frankly, is not what we should be doing or saying, given the track record of how our military has performed in the area of sexual assault. The problems that you see in the military are all over the country. They're just talked about more in the military. The people in the military should be held to the highest standard. But you will fix no problem in the United States military if you deal that commander out.
The senator yield for a comment. And in fact, the evidence is, looking at the facts, that commanders are bringing more cases, are pursuing more cases than over the recommendation of their JAGs in sexual assault cases. The evidence that we've gotten from a letter we received from Admiral Winnefeld, the deputy of the chairman of the Joint Chiefs of Staff, basically he had pointed out that there were over 90 cases, in fact, where commanders had a different view than their JAG, said a case should go forward, and guess what? Convictions were had and people were held accountable.
There are situations where joint jurisdiction lies. The military has jurisdiction, the civilian community has jurisdiction. There have been cases where the civilian community went first. There were 49 cases in the Army where the civilian community decided not to prosecute in sexual assault that the Army took up, and they got an 81% conviction rate. In the Marine Corps, 28 cases turned down by the civilian community where the Marine base was at that went to court, 57% conviction rate. In the Navy and the Air Force, it's the same thing, where you have civilian jurisdictions saying no to the case, the military saying, yes, we're going to go to court, because there's a difference between what the civilian community is trying to accomplish and what the military community must be trying to accomplish, and that is to let the troops know that their certain conduct is out of bounds, and if it's even close, you're going to pay a potential price. Now, having said that, please do not blame sexual assault problems in the military on a broken military justice system, because it is not broken. The commanders are not telling the lawyers take a hike. The cases the lawyers recommend to go to trial actually do go to trial. And juries in the military, it's not a juries of one peers. This is not a civilian system. Everybody who goes to trial as an enlisted man is judged by officers. You can request 1/3 of the military jury to be enlisted members, but they're going to be the most senior people on the base. Please understand that military juries are not constructed the way civilian juries are. They're told to be fair, and they do their best to be fair. But it goes into the concept of how the military works. The only person entitled to a trial in the military of equivalent rank is an officer. An officer cannot be tried by people of lesser rank. And that may sound unfair, but in the military it makes perfect sense, doesn't it, Pat? Officers eat in one corner of the base, and enlisted people eat in the other corner of the base. Not because they hate each other. They admire and respect. This chain of command, these lines of authority, make us... I'd ask for 1 extra minute if I could.
Sir, objection. So ordered.
Thank you. This unusual situation for most Americans works in the military. It may not sound right to you, but it works, because the military is about, when you're ordered to do something, you answer the order. You don't debate. So if we don't elevate the commander to have the tools available to make the right decisions, and if we don't instill those below the commander to follow, it all breaks down. And when a commander lets the troops down, and they do sometimes, fire the commander. Don't take away the authority of the commander to win wars that we will inevitably fight. This is not a civic organization. This is not a democracy. This is a situation where one person can choose to send another person to their death. That person is the commander. And there are plenty of checks and balances. Ladies and gentlemen, sexual assault is a problem, but for God's sakes, let's don't tell every commander in the military, you are fired. You are morally bankrupt. You're incapable of carrying out the duties of making sure that justice is done in these cases.
Senator's time has expired.
Mr. President.
Majority Leader is recognized.
10 on each side.
I assume Kirsten needs 10.
Okay. Mr. President,
Senator, Majority Leader.
I ask unanimous consent that the motion to recommit that be withdrawn. Pending 11 Amendment 2123 be set aside for Senator Gillibrand or designee to offer amendment number 2099 relative to sexual assault. That the amendment be subject to a relevant side-by-side amendment from Senators McCaskill and Ayotte. Amendment number 2170. That no second-degree amendments be in order to either of these sexual assault amendments. That each of these amendments be subject to a 60 affirmative vote threshold. That, Mr. President, I am told that each side would like 10 minutes. That is, the McCaskill side and the Gillibrand side would be 10 minutes to close. If there are other people who want to speak, now is the time to say something.
Mr. President?
Yes.
Assistant Majority Leader is recognized.
You want some time?
I would like I understood there were 30 minutes left on the Gillibrand side.
How much time do you need if I get this consent agreement?
10 minutes.
Okay, so we need 10 minutes for McCaskill also. So that would be 20 minutes on each side. At the time then until 5:30. Be equal dividing control between the proponents and opponents of the Gillibrand amendments and the McCaskill amendment. That the Senate proceed to vote in relation to Gillibrand first, and upon disposition of that, the Senate proceed to vote in relation to the McCaskill amendment, and that there be 2 minutes equally divided in between the votes. Finding no motions to recommit during the consideration of these amendments be in order.
Is there objection?
Reserving
the right to object. Go ahead. The senior senator from Oklahoma.
Thank you, Mr. Chairman, or Mr. President. I would like to ask the leader if he would amend his request to add the following language. Following the disposition of the McCaskill-Ayotte amendment, all pending amendments be withdrawn and the Republican manager or his designee be recognized to offer the next amendment in order, followed by an amendment offered by the majority side, and that the two sides continue offering amendments in alternating fashion until all amendments are disposed of.
Will the Majority Leader modify his UC?
Mr. President, we went through this yesterday. I reluctantly object.
The objection is heard.
So
Is there objection to the Majority Leader's request?
Reserving the right to object.
The junior senator from Oklahoma is recognized.
You know, this is a very important bill for our country in terms of authorizing the defense of this country. And many of us have relevant amendments, not amendments outside the scope of this bill, but relevant amendments that will actually markedly improve the way we conduct policy in the Defense Department. And without the assurance that those amendments are going to be able to be offered, they can be tabled, but without that assurance, it makes it difficult to agree to a consent, not knowing whether or not we will have the opportunity to represent the people we represent in offering amendments that will make positive improvements to this bill. And so I would put forward that we're really not conducting the business of the country if we're limiting the ability of members of the Senate to offer amendments. And absent that guarantee, I will object.
The objection is heard.
Mr. President, I would...
Majority Leader.
We have 350 amendments that have been filed on this bill. Every person that filed an amendment, I know they feel very entitled to offer that amendment, but I just think that we're not in a position to deal with this for all the reasons that we have talked about here for several months. We're not seriously legislating anymore, and we can pass the blame to anyone we want to do that. But, you know, we've tried all kinds of things. How about so many amendments on each side? We've done that before. That's nothing that's heretical. It's nothing that is unique. We've done that lots of times in the past. That doesn't work. How about 13 amendments? No, that won't work because we want more amendments after that. So I understand, and I'm not denigrating anyone's intent. I know the intentions are good. My speeches, the record reflects how I feel about this bill. But I'm sorry we're at the point we're in. Couldn't we at least, everybody, vote on this amendment that people have spent days of their lives working on? It doesn't matter how you feel about what has been done, but there's been tremendously important work done on this sexual assault issue. And we should at least have the opportunity, with the work that's been put into this, to have a vote on this. No one is disenfranchised by doing that. We'll move to try to figure something else out after that. But gee whiz, couldn't we do that? Otherwise, we will walk away not having done anything on this. I think that's just so unfair to the people that worked on this. I know that other people have worked hard on their amendments, but I would have to say in the last year or two, no one has worked harder on amendments than the proponents and opponents of this amendment. So, Mr. President, having said that, I've got consent here that I have someplace. Oh, here it is. Okay. I ask unanimous consent that we move to a period of morning business for debate only until 7:30 p.m. tonight.
Mr. President. Was there objection? Senator from Michigan.
Was that a unanimous consent request?
Yes, it was. Yes.
And of course, while reserving the right to object, I will not, but I will say this. I can't tell everybody in this body how disappointing it would be if we do not finish this bill tomorrow night or Friday, because the issue is this. We all ought to face it. There's only 1 week left where both the House and the Senate are going to be in session. If we don't finish this bill this week, there cannot be a conference report. And then for the first time in 52 years, there will not be a defense authorization bill in the absence of some miracle. I would plead with our colleagues to let us vote on this amendment. The alternative was a list of 13 amendments, which we were willing to then move to. That wasn't satisfactory. I mean, we've got to do this step at a time, and we've done it that way before. We can't even get cleared amendments agreed to, where both sides have cleared them into a manager's package. Now, if senators want to vote tomorrow or Friday against a cloture petition because their amendments haven't been reached, they're free to do so. That is plenty of, quote, leverage, which I guess is the currency around here, tragically. But I would plead, and I know Senator Inhofe and I have worked so hard on this bill, and I think he feels the same way. We need to get this bill finished this week, or else we're not going to get a conference report.
Reserving the right to object
Mr. President.
to the unanimous
Majority leaders recognized.
Mr. President. I'm sorry. My friend, one of them.
Senior.
And I would say, while they're reserving their right to object, there's still time left with the tentative agreement we had. It was just a kind of a handshake that there would be 6 hours, is that right? And there's still time left on that. So the time for debate only, that time could still be used.
Yes. Is there objection to the request?
Reserving the right to object.
Reserving the right to object.
The junior senator from Oklahoma is recognized.
First of all, the amendment we're talking about isn't pending because the tree has been filled. So we don't even have an amendment pending.
My consent.
76 times the majority leader has filled the tree, more than 2 times all the rest of the Senate majority leaders in history. Last year, under Senator Levin and McCain's leadership, we considered 125 amendments, or thereabouts, some in a manager's package, others. There was over 300 amendments offered. The average length of time to consider this bill is about 2.5 weeks. We've had it up less than a week. And the fact is a consideration for a budget, an authorization bill in excess of $500 billion, and we're not going to have amendments on it. So there's not a unanimous consent that I want to agree to until we agree to open up the Senate to allow members to offer their ideas. Table them. The fact is if we run this just like we did last year, we'll be through with this in 5 or 7 days. If we continue to do what we're doing now, we won't finish it. And it won't be because we don't want to finish it. It's because we won't have the opportunity to put input into a bill that is over 50% of our discretionary spending in this country.
Is there
Mr. President, yes, reserving the right to
Senior senator from Oklahoma.
I think when we are going through exercises like this, there are some people who want to have their program placed on a must-pass bill in order to get something through. The senator from Oklahoma, the junior senator from Oklahoma, made it very clear that he's talking about something that he feels is relevant to the defense of this country, and I think that sounds reasonable. What I'd like to suggest to the majority leader and to my very good friend with whom I've worked for many, many years, the chairman of the committee, Chairman Levin, is that we can qualify and work on a UC that would either use the words germane, relevant, or related in some way so that those amendments that had nothing to do with defending America might be able to be considered in some form, maybe a limited form. I would like to be able to sit down and see if something like that could be worked out before giving up on this thing.
Is there objection?
Mr. President, I have...
Majority Leader.
Yes, I know that there's a unanimous consent request pending. I have no problem in the world with their continued work to see if we can come up with something. We've tried. It's not as if we haven't tried. But my disappointment is that we're just not doing any legislating here. And people can point all the blame to me all they want. And we can get into all kinds of statistics if we want about what's happened in years past and why it's been necessary to fill the tray. But that doesn't accomplish anything. Everyone kind of knows what's going on around here. So I'm not going to get into a he said, they said situation. I know that the two managers of this bill want to get something done, and let's give them the time it takes to get that done. So my consent is pending, and I would like the chair to rule on that.
Is there objection to the request?
I object.
Yes.
No tabs of quorum.
Clerk will call the roll.
Mr. Alexander.
Mr. President,
The Majority Leader is
I ask
recognized.
unanimous consent to call the quorum be terminated.
Without objection, so ordered.
Mr. President, I would renew my request that was just denied. And I would also add to that I be recognized at 7:30.
Is there objection? So ordered. Mr. President.
Senator from Ohio.
Thank you, Mr. President. I ask unanimous consent to dispense with the quorum call.
Without objection.
Thank you, Mr. President. It's with pride and humility that I stand and thank my colleagues for passing Senate Bill 381 by unanimous consent last night. Passed by the House, once passed by the House and signed by the President, this bill will award congressional gold medals to the surviving World War II heroes we know as the Doolittle Tokyo Raiders. The effort to pass this bill has been a personal one for me. I thank 78 of my colleagues who have co-sponsored the resolution. It proves the Senate can reach consensus recognizing the service of men and women who have worn our nation's uniform. I want to thank Secretary Boozman, who was my original Republican counterpart in introducing this bill in February. Also original co-sponsors Senators Murray and Baucus and Tester and Nelson and Cantwell and Schatz, original co-sponsors. I wish that Senator Lautenberg, also an original co-sponsor and a close personal friend, the last World War II veteran in the Senate, I wish that he were here today to see its passage. A special thanks to Senator Cornyn for his work on this, and especially Senator Ayotte. They have my personal thanks for helping to bring so many Republicans to sponsor this bill with us. Many of you know the story of the Doolittle Raid. 71 years ago, following the attack of Pearl Harbor, just 4 months earlier, 80 brave American airmen launched a mission that would become our nation's first offensive action against Japanese soil in the Second World War. They volunteered for what was called an extremely hazardous mission without knowing at the time what it actually entailed. Under the leadership of Lieutenant Colonel James Doolittle, the raid involved launching 16 U.S. Army Air Corps B-25 Mitchell bombers from the deck of the USS Hornet, a feat that had never been attempted in combat before. On April 18, 1942, again just a few months after Pearl Harbor, 650 miles from its intended target, the Hornet encountered Japanese ships. Fearing the mission might be compromised, the raiders decided to launch 170 miles earlier than anticipated. These men accepted the risk that they might not have enough fuel to make it safely beyond Japanese-occupied China. The consequences meant the raiders would almost certainly have to crash land or bail out, either above Japanese-occupied China or over the home islands of Japan. Any survivors would certainly be subjected to imprisonment or torture or death. After reaching their targets, 15 of the bombers continued to China. The 16th, dangerously low on fuel, headed to Russia. The total distance traveled by the raiders averaged 2,250 nautical miles over a period of 13 hours, making it the longest combat mission ever flown in a B-25 during the war. Of the 80 raiders who launched that day, 8 were captured. Of those 8 prisoners, 3 were executed, 1 died of disease, 4 survived as prisoners of war and returned home after the war. The Doolittle Raid was a turning point for the Pacific Theater and set the stage for the Allied victory. Of the original 80 raiders, 4 survive today. A raider from Cincinnati, in my home state, Major Tom Griffin, passed away on February 26th of this year, the very night I introduced S-381. Major Griffin was the navigator for plane number 9, the Whirling Dervish, on the Doolittle Raid. He survived the mission. He'd continue to fly until he was shot down in 1943 and held as a German POW for 2 years. When the war ended, Major Griffin returned home to Cincinnati, later owned his own accounting business. Like our veterans past and present, he asked for nothing. These veterans served simply because their nation asked. For many years, the surviving raiders gathered to celebrate the mission and to honor their departed fellow raiders. This year's celebration was bittersweet. It was their final reunion, they decided. All the remaining raiders are in their 90s. It's becoming hard for them to make the annual trip. So it was decided this would be their final reunion. This is an article, Mr. President, a story in the Plain Dealer in Cleveland of the final reunion, which took place in Dayton, Ohio. The 3 remaining survivors who could make their trip, 4 are still living, only 3 could make it, called out here as an historian read the roll call. They then raised a goblet inscribed with their names. They toasted their fellow raiders with a bottle of 1896 cognac, a bottle that Commander Jimmy Doolittle passed down for the Raiders' final toast. 76 other goblets were turned upside down, one for each of the comrades who had passed away. Hundreds of people watched the solemn ceremony and offered their respects. Speaker Boehner, whose district is nearby, Dayton, Ohio, sent a letter in honor of the occasion. An Associated Press article on the ceremony, a 12-year-old boy whose grandparents brought him to the event, said, quote, "I felt like I owe them a few short hours of the thousands of hours I will be on this earth." This journey started 2 years ago for me when Brian Anderson, the Sergeant-at-Arms for the Doolittle Tokyo Raider Association, approached my office seeking a proclamation for the 70th anniversary of the raid. We achieved that goal passing Senate Resolution 418 in August 2012 by unanimous consent, but that wasn't enough for Brian. It wasn't enough to honor these men and what they had accomplished. We set our goal for awarding the Congressional Gold Medal, the highest civilian award bestowed by Congress, limited to 2 a year in this body, to the Raiders. This honor is designated to those who, quote, have performed an achievement that has an impact on American history and culture that is likely to be recognized as a major achievement in the recipient's field long after the achievement. These 80 veterans meet that description. They exemplify our highest ideals of courage and service. They deserve to be recognized. President Kennedy said, "A nation reveals itself not only by the men it produces, but also by the men it honors and the men it remembers." We, our nation, honor those who serve. I call on the House and I call on the Speaker to quickly act on this legislation. Sitting in the chamber today is a senator, the senator from Texas, the senior senator from Texas, who played a major role with Senator Ayotte and others in gathering co-sponsors for this Congressional Medal of Honor. I thank Senator Cornyn for his work on this. And, Mr. President, I yield the floor.
President.
Senator from Texas.
Mr. President, I want to turn the compliment around and extend my appreciation to Senator from Ohio, Senator Brown, for his leadership on this issue. This is long